Well, welcome everyone to this month's T3. We're happy to have Laura Smith Hill, and I'm guessing maybe she's persuaded some colleagues to join her in this discussion about participant eligibility. This is an important topic and an ongoing discussion, I know, within our state, and I appreciate Laura and her staff taking on the facilitation of this discussion today. So Laura, I'm going to turn it over to you.
Thanks, Becky. Good afternoon, everybody. Yeah, this topic, as I think about the title and the topic today, I would invite you to consider the image of, if I had an emoji, you might see a target that's moving, and like someone is behind it. We can't see their face. Someone is behind the target and they're running away from us, and we're trying to hit that running target. Oh, that's perfect, John. That is so perfect. So that's what we're looking at today is a moving target as the business rules for the state regarding PRWORA are evolving. And so today is just an introduction about some of what we might expect and what kind of documents we need to become familiar with as we progress down this journey. Okay, so what is PRWORA? Here's what the acronym breakdown is. And we're looking back at 1994, maybe earlier, where this was initially utilized. And so we're bringing up something that was used previously, and there has been some guidance, very minimal guidance that was provided to us through Octave about PRWORA and how it may impact us, and we await further clarification. As that target is moving for us as programs, it's also moving for our statewide leadership, and it's moving for those who are serving us at the federal level, where things are not crystal clear yet. But I trust that this discussion today will be informative, and I've asked and invited both John Anderson and Amy Quiroga to jump in and add to the conversation at any time. Some of what you see on the screen before you comes from the draft business rule put forth by our state leadership, and this is something going on above John's level, where these discussions are being had about what does this mean for South Dakota? What might these business rules look like? And while there is the conversation going on amongst stakeholders, we know these decisions are likely being made at a higher level. So statement right before you, the business rules are evolving. We know they're evolving, and we can share with you today some of what our program has been doing to prepare for PRWORA, so that you can glean from some of our experiences as a local program. So you see at the bottom that it looks like adult education providers will need to take some action to demonstrate eligibility for services. And today we're going to talk about what acceptable documentation might look like. I'll maybe pause. Whoops. Pausing here. John, is there any further context you want to offer right now as we lay the ground?
Yes, and I would just note that OCTAE, right, the Office of Career, Technical, and Adult Ed under the U.S. Department of Education, actually didn't provide specific guidance. They gave us a letter of interpretation, And then in the chat, I linked the Federal Register, which is only 6 pages in length, but it's very dense. And if you will look at page 1 of that document, that Federal Register Volume 90 from July, first page, right-hand column under background, bottom of the first complete paragraph, you'll read PRWORA defines qualified alien to mean, and then it enumerates 8 different categories there. And so I don't know if we can, as we rely on your experience, expertise, and while we try to hold inviolable your inclusive, safe classroom dynamics built on rapport and respect, please share your concerns, ideas, and any questions you have so we can illuminate these considerations before DLR operationalizes these efforts. Right. And I think it's worth noting, Laura, that nationally there are 24 states who have sued, and the case is adjourned, and perhaps with resolution comes a rescission or potentially guidance. And so there are just a number of uncertainties. So we're trying to not get ahead of ourselves and create unnecessary overreach. But at the same time, I think state leadership, given the dynamic, does not want its valued adult ed providers and students and partnerships to be at risk of non-compliance. So we're threading that needle. Thank you.
It might also be interesting background, and Amy, you can think about if you want to share anything in this regard, but as she and I have been talking through from her role as a coordinator, my role in directing, that we've been through changes on who is eligible for services over the years, over our 20 some years of being involved with adult education and literacy. So we do, I'm appreciative that we have that background of, there was a time where our eligibility for service looked similar to what PRWORA is proposing now. Do you want to talk at all, Amy, about some of the historical changes that we've been through?
I can, but honestly, I think you've summarized it quite well. If there is time for more detail, sure, I can talk, but I think, yeah.
Thank you. I appreciate your expertise. We've worked on a lot of this together, which is really helpful because PRWORA does impact for our program. It impacts how we conduct our enrollments. So you will hear today some touch points with the journey to enrollment. I want to credit Amy with this incredible visual that helped me to understand the different tiers of who's eligible that we've looked at over the years. And you can see it. I think it's wonderful. And we chose the colors together so you can see the differentiation. That PRWORA is having us look more narrowly toward the center of this moving target of those who are permanently work eligible and lawfully present permanently. So it really, as we look at the list that you'll see on the next slide, largely what you see on the screen are documents that prove that someone is permanently eligible to work in the United States. The next circle outside of it, you see work eligible. that would include temporarily work eligible. That is not the emphasis or target of PRWORA, unintended. And then the exterior circle are all those who are lawfully present. That is a much broader category. And as a local program, our focus the past 2 years has been serving those who are lawfully present because of the way that we as a state interpreted the federal guidance over the past couple of years. Now we're looking at taking some steps back and making it a more narrow view again. How's that so far? Any questions so far? So here's some meat on the bone. This list was derived from the draft business rule for our state. As I mentioned before, that is evolving. And these are some things to keep in mind. And Amy has graciously embedded in our slide deck for today some images of these types of documents. But we can discuss these for a few minutes. We, as a local program, this step has included not only understanding them as people who serve as a director, associate director, coordinator, or supervisor, but also for those that help with the enrollment process. In our program, that's a pretty wonderful team. It's a wonderful team of people that extends beyond those who have a supervisory or coordinator role. And so we're training and do ongoing training on what these documents are, and are really, really fortunate to be able to bounce ideas off each other. And Amy does field a lot of questions as they come up. We're able to talk things through. Know that we're also very willing to be a resource if your programs have questions about these documents, but it's not terrible. It's not it's more of the outliers that have us scratching our heads. We find this list to be quite comprehensive if we're looking at just those who are permanently work eligible in the United States. I've done a little research. The only things that might be missing from our many years of practice could be U visa, T visa, or VAWA recipients. So those that are victims of crime, victims of trafficking, and women affected by the Violence Against Women Act. Those are a kind of a gray area that we're questioning that legally might make sense to be included here, but we're not certain about that. That's just a question for us. As you see on this list, the first item is actually the only item from our understanding that has an expiration date that may be relevant to someone's work authorization lapsing or concluding. Because in South Dakota, that real ID can be obtained with temporary work authorization from what we're seeing so far. Anything to add there, Amy? I know you were doing some research on that.
Sorry. I don't believe so.
Okay.
Yeah.
Simple, like in a nutshell, this is the one document that could include temporary work authorized individuals. Items 2 through 11 are quite straightforward in as much as they are indicating that someone has permanent residency in the United States. It is highly unlikely that any one of these document holders would lose their status as a permanent resident in the USA. And if you look at number 11, that EAD, our program in Sioux Falls sees a lot of people with EADs that are not A3 and A5. those under this PRWORA interpretation would no longer be eligible for AEL services. And you can see A3 is a designation for a refugee, A5 is a designation for asylee. And that is someone called, that person would be a post-grant asylee, not someone who has applied and is waiting for their asylum to be approved. We also serve a lot of people that are seeking asylum in the United States, and there is a wait. There are wait times to find an attorney, get an appointment with an attorney. Our own wait list is out until spring, May of 2026, if not further. And we rarely accept asylum applicants. We refer them and have a great long list of regional providers of asylum law, legal application support. So that being said, once they are approved, which is a process that can take 2 to 5 years, then they are AEL eligible under this PRWORA interpretation. Number 12 and number 13 are a bit special because, and that's why I put them in gray, because they could represent a gray area without further training. The notice of action from USCIS can take many, many forms. A notice of action is simply a letter from the USCIS giving you an update, but those updates can range greatly in nature. The types of NOAs, Form I-797s that could be relevant to PRWORA, I've made note on your screen here, would be replacement document notices for the documents listed above for up to 2 years. While if you look, a lot of this you can just find by looking at the USCIS website. And you'll notice that they say their acceptable processing times for a legal document is up to 24 months. It's often up to 24 months. So if someone has that notice that they were eligible for and had a green card, they've applied for a replacement green card, it's not, no one can complain. That's what those timelines are for on the website, is to give some protection to the USCIS that no one really has a right to complain if they're waiting for less than 24 months for that replacement document, as an example. Orders from an immigration judge, that number 13. These are some examples. Now, the state provided withholding of removal, and I can concur with that. We can concur with that from our experience as a program working with lots of types of immigration status. And here are the codes that you could look for if you end up being on the receiving end of this document. The order from an immigration judge with the code A10, C10, or C18. Those 3 specific orders point to indefinite resident status, an indefinite legal resident status. Whereas other orders from an immigration judge likely would not be pointing to legal resident status and wouldn't be parallel to the other items we see on this list. 14, I don't think we've seen before as at our local program. And then 15 through 17, I don't know, John, if you would like to say a few words about how that might relate to those who are working with Department of Corrections students.
Mm-hmm. Yeah, and already I think 15 has been struck. Who's going to work on my past participles there? Has been deleted from the tentative list, but they 16 and 17 specifically are for our correctional partners and following their protocol. I would just like to, as prologue, note that I included some language that this list is not necessarily comprehensive, and that, you know, as of right now, it is malleable, and hopefully we can craft it in a way that allows a certain amount of adroit latitude to respond to forthcoming changes, if indeed this becomes operationalized and formalized at the federal level pending that lawsuit with 24 states. So, and then of course, real ID for those who aren't familiar, that would be a South Dakota driver's license or a South Dakota ID. And there are some differences even across the border with Minnesota IDs and real ID compliance versus South Dakota driver's licenses and state IDs. So how can we frame this in a manner that is truly part of work readiness or part of civic engagement or one of the other statutory purposes as articulated under Title II in WIOA?
We'll be able to share some examples of that
Good.
for other programs to consider. Thank you, John, for adding context. Anything else to add? Any comments or questions about this?
I have, I don't know how many questions you want to take. These questions are standalone, so they don't really relate to each other. But item one, the real ID. So now I understand that's South Dakota driver's license or South Dakota state ID, if obtained with a temporary work authorization. So my first question is, so does PRWORA include in their target a certain number of people with temporary work authorization if this real ID would make them eligible?
And Laura, you might have some response to that, but my priorities right now as they stand, because this, to Laura's point, right, the effective date was what, August 9th? Is that right? The initial effective date, I believe, was August 9th. And so DLR leadership has been wanting a business rule or some sort of policy or procedures in place as part of due diligence. But in the absence of federal guidance, it's 57 states, districts, and territories, minus the 24 who are enjoined in the lawsuit, attempting to navigate this. But Jeremy, what I would like to do is avoid temporary work authorizations at all costs, because at one point DLR wanted a quarterly revisit where we were monitoring ongoing statuses. And I wanted to parallel all of our other enrollment activities. That is, what is the status at the time of entry? And let's just leave it at that. Outside of LSS, the rest of us aren't necessarily, well, and I know Cornerstones and Southeast and a number of you are involved, but I'm certainly not an immigration expert. I don't work for USIS, and I don't have, any training. I mean, this isn't statute. This is interpretive rule that even the feds admit is not binding. So we're in definitely that gray area mentioned previously. So Jeremy, part of my priority is to minimize the burden and the follow-up and just determine at the time of entry this additional criterion for eligibility. Did that answer your question?
Yes. Yep.
But John, I would say also from a programmatic perspective, I don't want people to leave here thinking we can't serve anyone who's got one of those temporary work authorizations in our program at all, because some programs might be looking at alternate funding sources to provide services to some of these people who would otherwise be shut out of adult education programming. So I don't want people to hear that as a hard and fast, don't do this answer. You know, you're always going to look at what your program is able to provide, regardless of whether that funding comes from those federal sources or if it comes from other outside sources.
I'm glad that thank you so much for mentioning that, Becky. That is so important. And part of what our program locally has been doing is coping with multiple layers of eligibility, because there are programs in our state that have different grants that we're working with. And each grant unto itself has specific requirements. So be mindful that we're here just talking about AEL, AFLA, and your programs are working with a multitude of, sometimes a single source, but sometimes multiple grants that have different expectations. I am so grateful to Amy and the team, all those that have been working so hard to update documents and eligibility for actually a couple of different grants at the same time. This is just one of them, but a big one.
Laura, if I can just make a quick comment. So as far as the permanent residents, people who have a green card, it's our understanding that even if the green card itself is expired, has an expiration date in the past, that their status itself is permanent. Therefore, they are still work eligible. Therefore, we can still serve them even if the date on the card is expired. If they have applied for a new green card, which of course most of them will have, wait times are very long right now. So they will have number 12. They should. They should have number 12 in notice of action, I-797. And that everyone who applies to renew their green card will get that because of the very, very long processing times.
What about number 8, Amy?
Yeah, we have, I think, on the next page, Isha, an example of that. So this uses the word stamp, but actually I would call it a sticker. It basically just means it's an immigrant visa. That's what it is. It's just a visa, a passport page size sticker in their passport, and very clearly across the top it says immigrant visa. That is good for 1 year, meaning they have a 1-year window to enter the country, but it also denotes permanent status. So even if they do not yet have a green card because they're waiting for it, they're an immigrant. They have immigrant status, so they're permanent. So it says stamp, but really it means visa or sticker.
And it's encouraged that someone would apply for their green card as subsequently to utilizing that stamp to indicate it's not a legal travesty in any way, but it typically does expect that someone is going to be applying for a green card subsequent to using that stamp for their document. Sticker stamp.
Laura, can you please speak to number 9 and 10 again, and what that means for refugees and asylees that are coming, and how to determine who seems like they may not be eligible for services anymore?
Yeah, Laura, maybe we could show the images. Would that help? Okay.
It might help. So Amy helped our program out by putting this together. And as John mentioned earlier, I'll just give a little brief intro before we answer Desi's question, that we did take this as an opportunity to train our students on English that will be really helpful for them. We've noticed in our citizenship classes and other interactions with our clients that they tend to not know the name in English for the document they possess. And even when engaging in that English at an office or an organization where they're talking about eligibility and documents, we felt this was an opportunity to empower our students with the language of documents so they can better advocate for themselves and communicate out in the community. So I just say thank you, Amy, for creating this visual.
Yeah, so for this, I just tried to include, there's a couple more slides of this as well. I just tried to include the documents that are the most common or that some of you may not be very familiar with. So this first one here, refugee travel letter, I believe in the list, that was one of the things that you had asked about, Desi. It's just a piece of paper. You know, it's not a card or anything. It's just a piece of paper, a letter from the government that says the client's name and date of birth, etc., like this. But it is issued by the U.S. government, and so it grants them refugee status, which is permanent. So this indicates a permanent status. And the second document here, the I-94, they do not any longer, for the last 12 years or so, give paper copies of this. Honestly, students and clients, they might not even know that they have this. There is a website that you can look it up for them using the document that they do have, but this is just a record of admission into the country. So where you see toward the bottom of here where it says class of admission, that is the code which would indicate, I'm looking at my list, that would indicate refugee or asylee status. And we think that we have looked at refugee status is connoted with RE and asylee with AY, though I am not sure that there can't be other codes potentially as well. We would need to look into that more carefully. Yeah. I don't know if that answers the question.
So in short, these documents are evidence of permanent work eligibility in the United States. Truly, and you wouldn't have to worry, Desi, about that expiring. If we see this, we know they're secure. They're encouraged to. That being said, they're a refugee or asylee. Asylee, I'm not as sure about, but a refugee after 1 year of residing in the United States is encouraged to apply for a green card. And then they do have an opportunity after 5 years of residency to apply for citizenship.
Okay, thank you so much.
No problem. Any comments or questions about this slide?
Can we get copies of these? Just, I think they'd be helpful points of reference just to have on file here for those of us who aren't as versed.
You comfortable with us sharing that, Amy?
I am.
Okay, thank you. So looking at the bottom right-hand corner, we talked about EADs. There are many, many EADs that are not permanent work authorization. So we would be looking here for what code? We'd be
So where
looking.
it says category, just after their A number, this one says category A02. Yes, so we're looking for code
A3 or
A03,
A5? Yeah.
right? A03 or A05.
So if you were serving this person, you would talk to your program leadership about what they would be eligible for other than AEL.
Can you repeat those code numbers, please?
A3, A5, and it is here on number 11.
And I got to remind you, this is all
Okay, thanks.
draft. None of this has been through DLR's legal review yet. It hasn't been finalized. But it has changed so much just in the last 6 weeks that we thought we really ought to share and get your insight, make you aware, and take any of your expertise, concerns, or suggestions to DLR leadership as we navigate and try to.
John, I just wanted to tell you too, I had done a little bit of digging on the tribal documentation. And kind of what I was looking at was the Indian Citizenship Act of 1924 kind of gave the leeway to have tribal documentation. And it doesn't show citizenship, but it's less than 1%. It says that all of the exceptions of people that have a tribal ID that would not have citizenship is well under 1% of tribal ID holders. So I'm just wondering why they might not consider that, just because of the financial burden it would try to dig up.
I know it's and
For a
I want to see tribal ID added to this list. And we met with North Dakota, my colleague in North Dakota, and DLR leadership yesterday. And North Dakota's using tribal ID, and so I'm still hopeful, Steph. But if you want to send me that citation from the what did you say it was? The
Well,
Indian.
it was, I'm trying to see where I found it, but anyhow, what it did is it referenced the Indian Citizenship Act of 1924, and what it was really saying is that the only exceptions for people that have tribal IDs are really people that are either part of the Canadian First Nations or Mexican Indigenous individuals who are recognized as a cross-border heritage, so they have dual enrollment. And so otherwise, people who hold tribal IDs would definitely be citizens by birthright. So it's well under 1% of all tribal document holders.
Yeah, and to me, that is more than sufficient. Yeah, I really want to see tribal IDs listed here. Absolutely.
Maybe, John, a combination of tribal ID and self-attestation to being born in the United States would help move the needle and appease the powers that be. I want to add that as we're talking about this being an evolving business rule that's not finalized, an encouragement that we can offer from experience is, even though this business rule has not been finalized, it is so beneficial for programs, not necessarily to turn away anyone from service just yet, but to be looking for these documents and to have consider making a photocopy. I'm not sure if we're quite at that point yet, but as a local program, we are making sure we get a photocopy on file whenever we can, because speaking from the school of experience, to go back to the students to try to get documentation after they've already been engaged in programming is much, much harder than being proactive and looking for those documents in advance so that you can save yourself some time and pain and resources later on when this rule does get finalized and clarified. So that's the proactive step that I would suggest. It's important for programs to start talking about what they can be looking for during enrollments. Is that fair to say, John?
Absolutely, Laura. And I mean, the valid talking point in framing this from DLR leadership, and right, our colleagues like in Title I, adult and youth, they've collected this for years. It was a prerequisite, but their programming has support services and can pay for childcare and thousands of dollars of tuition. It's very different. And because Title II isn't directly related to that, and we're sometimes conflating work authorization and qualified alien and cobbling together all of these different resources to try in good faith and due diligence to meet a vague interpretation that's not even binding. um, how can we best posit in a meaningful way our students for whatever their goal is? If it's not work readiness, is it citizenship? Is it around family literacy? And what document or documents make sense? And again, it wasn't that long ago where DLR leadership wanted multiple documents in certain cases, and had very unrealistic expectations about how we treat incumbent students. So I'm grateful for any breathing room and slow walking that we can do with this as we await any possible determination of the lawsuit at the federal level and subsequent ramifications thereof. But in the meantime, right, what can we do with current students and prospective students to secure? And I would note, North Dakota doesn't actually photocopy and collect. They verify and have the students sign a self-attestation. They will note which documents from their acceptable list, which document was presented, and then they will have a witness sign below the student self-attestation. But I don't want to put teachers' signatures on there functioning as witness. So again, yeah, we're trying to do the best we can here, but I'd like to hear some conversation at some point too. What percentage, after you take a look at your data and your student body, what percentage will have difficulty providing one of these documents? And how can we possibly continue to serve them without that documentation via other funding streams or partnerships or what have you until we get more guidance at the federal level?
Oh, Amy, is this the image, the stamp that you were talking about?
Yes, this is what they call I-551 temporary I-551 stamp. It doesn't say 551 anywhere on it, but it means immigrant visa. So that's this.
And we talked about notice of action
Mhm.
and orders from an immigration judge. So these visuals, those orders, withholding of removal, those would qualify under the current PRWORA interpretation. And then notice of action, it really depends on what it says there and what codes are used. And you can refer to the previous slide for those details if you encounter that. or feel free to reach out. So these are some things to consider and to start talking about and thinking about. These are applications that we've made to our local journey to enrollment that help us be poised to confirm eligibility under PRWORA. And that involves what type of text we include on our flyers for our program. We use translation mostly in Spanish there. We have text that we include on our appointment cards also that helps to start the process of seeing the names of documents that we're looking for at an enrollment appointment. And I know we have, I think in Sioux Falls, a really broad swath. Cornerstones, you probably do too, but you do have different grants that you're working with. So that might be part of how we funnel a client or a student into a certain grant project is what documents can they produce. We have a script that we have worked with, designed and customized at our front desk for the front desk staff and the coverage team. So everyone knows what types of questions to ask when scheduling an enrollment appointment. And it is not a one and done. It's not just a one question. It's every interaction that we have at our front desk is an average of 15 to 20 minutes per person. So it's not like working at the bank where majority of the clientele are native English speakers. We have to really take our time, say things in different ways, use first language supports when necessary. We also send a text reminder for their appointment, which includes, remember to bring your documents, this, or this, and we keep repeating that list over and over. And then when they come for their day of their appointment, so if you're looking at the middle of your screen, we have a script that's used the day of the appointment. Did you bring your document? Do you have it at home? Do you have a picture on your phone of that document? So we're coaching at every step of that journey to enrollment, integrating an awareness of a document that would be helpful for us at enrollment. And if they cannot produce those documents, we let them know what their options are, maybe a different program within your organization, a different grant, rescheduling, when they can bring their resources back if they don't have a photo on their phone. Sometimes that does work for us, to have a photo and consider other resources for learning. But we try our best to have options available so that we're not leaving people without if they're not eligible for this grant specifically. Additional resources that we have collated are our immigration attorneys in the region, and also a guide to local resources for those impacted by a loss or revocation of work authorization. As there are many in our community who were here or are here legally, lawfully, and have lost their work authorization and now are looking for resources that will support them through food insecurity. So these are things that we have as a holistic model to receive students and guide them accordingly when they come to our local program for resources. And here, oh, very nice. So thank you, Amy, for showing us the models of resources here in English and Spanish, where you can see these are some of the conversations we're having at our front desk. Do you have a social security card? Do you have a work permit? Do you have a green card? And we talk through it. We circle the document they say we have. We repeat it. Please bring it to your appointment. This document will let us know what type of services you're eligible for. And same thing, it's very similar in the text. It will look similar. Your appointment is scheduled for this day. Will you be present? Yes or no? And remember to bring these documents. If you have them, bring all the documents that you can. In our program, the more documents they have, the more offerings they're eligible for, because we also have some things like refugee case management and legal services, depending on someone's specific eligibility and status. And then securing that document, we do see in our draft business rule that programs would be responsible for filing proof of eligibility. Now, again, this could change. This is evolving, but we are preparing for it, because with the student body, the size that we're working with, it is very onerous to go back in time and to chase down those students and say, well, we didn't think we needed to copy, now we do need a copy. We would rather have it just in case we need it. And local program, at this time, we're looking at what are your local program standards for HIPAA, for protecting private information. It may include filing things in a locked cabinet, in a locked room or space, or uploading documents to LACES or using custom fields. So these are things that will also come into focus as we get closer to what our target truly is. And always, as always, consult your local program leadership for guidance on any of these matters. And John has been really helpful and available to us as we traverse what the future holds for programs, eligibility, and documentation.
Say, Laura, there was a question. I've heard this question. If you want to go to the slide with the list detailing the tentative list, there was a question because 6 weeks ago I didn't say we adopted, but it was tentatively foisted upon us that we should parallel what our Title I partners are doing. But again, they need to, and always have, need to prove work authorization, right? And people need to be eligible for financial support services, need to prove that they've registered for selective service when that's relevant, and have work authorization. We, you know, don't right now under this interpretation. It goes back to qualified alien. But there's one question, and I see that Kendra, my leadership has added before real ID, going back to that. The question is those I-9 documents, list A or list B and C. So that's still, so she tentatively put that back there. But if you can provide a list A or a list B plus C, to me, that's almost redundant, right? If not redundant. Because where we are now, and again, this is subject to change, but now they're only looking for one of these documents. And those USIS documents, and I can put the link in the chat so people can follow what I'm saying. List B confirms identity, where list C confirms work authorization, where list A confirms both of those. But we're not quite held to that because we're only looking at US citizens, US nationals, and this interpretation of qualified alien, what constitutes a qualified alien. So I don't know if there are further questions around that. But presumably, if you have a list A or a list B plus C, you've more than met this requirement already. Does that make sense?
If we follow the I-9 guidance and have list A or list B and C, then we are expanding our circle of eligibility to those that are temporarily work eligible. So there would be a distinction in the processes. We would be able to serve hundreds of additional students if we're allowed to use I-9 column A or B and C combos as opposed to the list where we're
See,
providing just one of these.
I don't see that. I need I have yet to understand how you could serve hundreds more with the I-9. And like I said, Kendra, as of yesterday, put it back in that list. But I just don't understand how a list A or a list B plus C would give you more allowability than the list we have here. So please, with specificity, help me understand.
Yeah, so the items on the I-9, A, B, and C include many examples, not on this list, that have an expiration date and denote temporary work authorization. They are absolutely work eligible in the United States, but they are part of the orange circle instead of the red circle. And yes. Amy, is there another way we can give an example of that?
So, I mean,
TPS is a common one that we have, temporary protected status. That TPS holder can apply for an adjustment of status, obtain a green card, but in the meantime, as a TPS holder, they would fall under I-9 eligibility, but they would not fall under this list.
well, what would they have? So work authorization be in list C. What do they have in list B that they don't have in our draft singular list? You know
Well,
what I mean?
yeah, John. So, like Laura said, for example, temporary protected status people or people who came as humanitarian parolees, things like that, they have they're not on the pathway to green card yet. Who knows, in the future they may be, but they're not on the pathway currently to permanent status. Now, TPS, for example, it can be renewed for 2 more years, renewed for 2 more years, renewed for 2 more years. They may have lived in the country 15 years, but they don't have permanent status. The government can and has revoked, depending on the country or the situation. It's incredibly complex, but the government can remove that work permission.
So
Can they
John,
get a driver's license or a state ID? I'm just looking at that list B. What can they produce in list B that's not on the singular list? Becky?
a Canadian driver's license.
Well, if it's a Canadian driver's license, would we consider them a US citizen, a US national, or a
No, but
qualified alien?
if they have a Canadian driver's license and a work authorization,
Yeah.
they
So
can work in
here's
the
where,
United
and
States.
here's where I'm gonna push back, and this is no change from my predecessor under Marcia Hess, where we prioritize adult ed services for those on immigrant pathways. And so again, many of you have heard this to the point where it's become threadbare, trite, and hackneyed. But I don't believe a student at the University of South Dakota, an international student, who's paying tens of thousands of dollars to the South Dakota Board of Regents, should then be eligible for Title II supports.
John, I don't
Maybe
believe any of us is
legally,
serving anybody who's currently enrolled in a post-secondary institution. I mean,
but they have temporary, like, because initially Kendra's suggested list included JVs, etc., right? That temporary work authorization. But one, it seems to engender the need for us to quarterly monitor students, which has me concerned. But two, if you're here working on a pig farm for a short term, should federal, state, and local monies support that pig farmer's training? I don't think so. If it's temporary work authorization, I think a fee for service sounds perfect, but I think philosophically, I can get behind some of this whereby if someone is a host of another school or business, the school or business should be responsible. Those international students should be practicing English at the writing center of the university, not co-opting a place in our classrooms. And I'd welcome arguments against, right? Or persuade me otherwise.
Well, John, we are, of course, we are happy to serve. We're happy to serve more than the red bullseye at the center of the target that Laura showed. For the last couple years, we had been serving the whole target, you know, all 3 rings of that. And this list that Laura was just showing us, this list that we got from the state narrows that significantly to the red bullseye. So it sounds like you would like to serve the second ring as well, which is work eligible. I mean, we'd be happy to do that, but the guidance in the list would not include that ring.
And what in the second ring, what documentation do those are those different forms of EAD? Do I have that right? Are those
not
different category codes of EAD?
Not necessarily. So the second ring, the middle ring there, they would be people who do not have green cards, meaning permanent residents. So the middle bullseye, the red bullseye, is basically citizens and permanent residents, meaning green card holders, just to make it simple.
And
The
refugees
second-
and asylees.
Right. Who have permanent, yeah. So the second ring
Well,
is people with work permits, for example. They have a work permit because they don't have a green card. A green card, if someone has a green card, permanent residence, they don't need an EAD. They don't need the work permit because the green card is also permission to work.
do those in the second ring work eligible? Do they have status that allows them to reside in the US indefinitely?
No.
Okay. And I'm not making these rules. Right. I'm doing my best to afford you as much latitude as we possibly can. I truly, I hope you don't see me as being confrontational here. I feel like I'm trying to run interference. But if we look at that citation I put in the Federal Register, right, the guidance we have thus far, and calling it guidance, clarification actually, is that they have to have lawful immigration status or immigrants holding specific humanitarian statuses identified by Congress. That's the definition of qualified alien. I would like to serve that entire ring, and I think we've been adamant, right? That's what made us special in the one stop. We didn't require work authorization or anything. You had to be 18 and not enrolled in a public school, not have a high school, and have a skill need. That was it. So, I know
It may be
maddening.
decided so far beyond our influence. The orange circle of people who are temporarily legally residing in the United States and serving employers and working in our businesses and wanting English and advanced skills in order to establish permanency. So many of them desire to go into the red circle. And there's a window of maybe 2 to 5 years where they're not there yet. And we'll have people from one year to the next that move from one rung to the other. And so checking once a year is sometimes advantageous to us because we pick up more that are AEL eligible. But right now it sounds like at the federal level, they're looking at red. And we have been doing orange. And we've been doing I-9, which is orange, and it's wonderful because we can serve more people.
Well, and to that point, like I said, tentatively, a list A or list B plus C has been added back to the list of acceptable documents tentatively. So I don't know, I guess whatever you can glean from that, if that proves helpful.
So John, did I just hear you say that this list now includes I-9 documents?
Kendra went into the draft, I believe yesterday, and wrote, yeah, document, and put it very first above. I'm going to copy and paste exactly what she put. She put it at the very top before real ID. Documentation in alignment with I-9 work authorization.
Okay, fantastic.
But again, this is in flux. So, and if I understood you correctly, list B and C allows us to get back into the second ring. Although I'm still a little unclear about what list B document you can provide in those instances.
Well, if we had time, we would maybe screen share it and talk about it. I know we've exceeded our allotment today, and I really appreciate the clarification, because that, John, that means a lot to our program that Kendra added that yesterday. And my apologies to the group that I wasn't aware that that line was interjected into the draft policy. So that's a whole other opportunity for training and discussion, is the Form I-9 categories A or B and C, which expand eligibility to the middle orange circle.
And I think that's honestly a nice way to bring us towards the end of our presentation, because it takes us right back to where you started, Laura. This is so much a moving target that unless you're checking back on a twice daily basis, you're going to miss an update. So I think this was so important for many reasons, just for some basic information about the direction that this is heading, for some good conversation to talk about some of those nuances. The I-9 means the tribal ID is back in play to some extent. So that's good news, I know. And so I think that the message that I'm taking away today is we need to be cognizant of what is already in the draft plan, and we need to start thinking about how we can begin to put together local plans for implementation, but that everything is so in flux that nothing at this point is definite. Is that fair?
On point, very fair. And ultimately, I'd like to see valid tribal ID stand alone. I don't know if I'm going to win that effort or if I'll prevail. But again, too, if you have other documents as you're looking at your current student files, don't hesitate to email me any sort of detail or justification, or I'm seeing this, because again, this is not comprehensive, and I think we're trying to keep everyone compliant, meet the spirit of the law while not overreaching, because that is my ultimate priority. For the programs, the staff, administrators, and especially the students. I don't want this to have deleterious effects. I don't want this to negatively affect partnerships and the trust and rapport. So please know that I'm doing everything I can with my modicum, with my very modest influence, as we move forward here. And thank you to all of the directors and staff who have shared and assisted and lent their expertise and day-to-day frontline empirical experiences to these conversations.
Yes, and thank you, Laura and Amy and John, for your valuable information and your leadership today. You're an excellent resource for the rest of us in the state with that very specific expertise that you have. And we appreciate you sharing it with us in honestly one of the clearest explanations I've heard thus far. So thank you for that.
Thanks
All
for
right. We're a little over time, but I think it's understandable with such a weighty subject. I appreciate you all for your patience and your input and your questions, and I hope you have a wonderful rest of your Thursday and a good weekend.
Thank you so much.
Thanks.
Thank
Take care.
you.
Bye now.